Look, as desired by Lordships, we have prepared a written argument. Right? Okay.
So far as accused number 2, 3, and 4 is concerned, Your Lordship.
Malhar, we have tried to refer to the evidence, how the trial court has, analyzed and dealt with the issue. Then finally, the legal submissions. In 3 broad headings, we have brought out our argument.
So we are submitting our also, it is ready. I am told that there may be some queries of the Honorable Court.
No, queries means on the last date when you were not there, Mr. Chaudhary has basically argued on 2-3 aspects. One of them is that according to him, there is no ingredient of any offense coming under the UAPA Act. That's his first argument. But he has fairly said that it may not be out of place to say that the IPC offenses, the ingredients may be there. That is his submission. This is number one. Number two, he says that the violence, if any, was a byproduct of the entire exercise. The idea was not to indulge in violence, but the idea was to raise a strong protest. That was the idea, and it may so happen that some people resorted to violence. And there are many other organizations which had indulged in these activities. So why only pick up one person who had given a clarion call to protest this statute or proposed statute while leaving out others? These are the two. Was that your argument, yes, Mr. Chaudhary? These are the two main arguments. And the third, we had made a query that has the learned judge dealt with this, the impact of or effect of these materials, such as telephonic conversation, etc., where some people are apparently speaking to the accused number 1 in preparation of an economic blockade. And to that extent, the economic blockade is also a facet envisaged by Section 15. So according to Mr. Chaudhary, those have been dealt with. Anyway, that we'll go through and we'll see. But he says that this terrorist organization, that would have absolutely no bearing here. And terrorist gang, the facts are not there to attract that. This is the sum and substance of their argument. What we wanted to add is, assuming that this argument is accepted, that there is no ingredient of UAPA, assuming, then also could the learned special judge have discharged them? Would he have discharged them? Assuming that
Yes, I got it. Yes. So these are the points I have. Yes. Last point first.
All right.
Section 20 of the NIA Act.
Yes, please give the NIA.
Power, Section 20 of the NIA Act says, power to transfer cases to regular courts, where after taking cognizance of any offense, where after taking cognizance of any offense, a special court is of the opinion that the offense is not trialable by it shall, notwithstanding that it has no jurisdiction to try such offense, transfer the case for trial of such offense to any court having jurisdiction under the code, and the court to which the case is transferred may proceed with the trial of the offense as if it had taken cognizance of the offense.
So he could not have discharged that.
Exactly, Lordship. If they are saying that UAPA is not there, IPC may be there,
Mhm.
the trial court would have the power under section 20 to set aside the charges under UAPA section 18 and section 39 and remand the matter by framing charge, remand the matter for trial to the appropriate court, which I was always submitting that the sessions court can try it. So
Right,
this provision is there.
right. Now suppose the court, after scrutiny of the materials, finds that for whatever reason, these observations are untenable for whatever reason. Then of course it is one thing. If the court finds that the ingredients do not measure up to a charge under 18 and 39, what is the recourse available to this court now? Because the
Yes.
learned judges also agreed that there could be ingredients under IPC.
Yes, now my humble submission is that we have come before this honorable court that there is violation of the principle of natural justice and NIA was denied appropriate and effective hearing. We could not make our submission complete.
Mhm.
When Lordship will remind it back, Lordship will not bifurcate the case into IPC and UAPA. Lordship will have to, in my humble submission, Lordship, will have to send it back for rehearing on the charge, lock, stock, and barrel. That means all the provisions, because we have to make our submission not only in respect of IPC, we'd like to make our submission on respect of UAPA also, because our hearing is not only restricted to IPC provisions.
Right.
On the other hand, this terrorist gang, terrorist association, terrorist organization, our case was very clear. In our charge sheet, I have not produced it because it is a part of the record. So in our charge sheet, what we have said, why we have taken recourse to terrorist organization or terrorist gang? Because the honorable court found that this deadline 22/6/2009 is very important, that notification. But our charge sheet, we have very categorically said. If Lordship is pleased to take
Yes,
160 hours charge sheet. Mark so that निकल गया क्यों? Yes, page 182. Our case was, it is a sheer open case for all the activities that were done not only from 2004, but very relevant was of November and December of 2019 also. So may I place 16.17, page 182 in our charge sheet.
Why don't you give the file? Give the file. Yes, page 182.
182. 16.7 up to 16.16, all the materials were referred to, including the legally intercepted voice calls, specific voice samples, video footage that had been sent to forensic laboratory for forensic examination and expert opinion. Reports and data are yet to be received. This was not received on 1/7/2011. We received it on 8/7/2021, after 1 week of the delivery of the judgment. That is, I have already now 16.17. After going through the oral, documentary and technical evidences brought on record during the course of investigation, it is established that accused A1 had several secret meetings with the members of CPI Maoists and had sent 15 cadres, members of KMSS, in batches of 5 each to train in camps of CPI Maoists. They were imparted with training in their ideology, handling of arms and explosives, tactics of mass mobilization to carry seditious activities in the garb of opposing lawfully established government. A1, along with his associates for the long period, has been organizing seditious activities disrupting government work in the state of Assam in the name of dissent activities or in democracy. which have a tactical resemblance, Lordship, this is very important, which has a tactical resemblance with the modus operandi of the CPI Maoist, a proscribed organization. Further, accused A1, A2, A3, and A4, along with others, had organized various meetings in the month of November, December 2019, and conspired to commit terrorist acts by using inflammable substances to strike terror in section of people, by causing widespread blockade in the state of Assam, thereby paralyzing the government machinery, causing economic blockade and disruption of services essential for life of community. The conspiracy and their subsequent provocative speeches caused enmity between groups, disruption of public peace, and causing widespread disharmony and disaffection towards the government established by law. In pursuance of this conspiracy, the mobs were provoked, leading to damaging of public property and grievous injury to officials in their official duties. The accused conspired to promote public disharmony, unlawful assembly in violation of Section 144 CRPC, obstruction of public ways, including railways, national highways, state highways, and internal roads in various places of Assam, thus blocking supplies essential to the life of the community, using inflammable substances, and thus subsequently causes damage to public utilities. Hence, accused A1, A2, A3, and A4 have committed offenses as mentioned below. So specific offenses are there. But we are very categorical. Our case was on a different footing. That 2009 notification has no bearing. When the Honorable Court in the order, we have found that he has given a lot of importance to that document. In that respect, we are making this submission.
Right.
Now, no UAPA. Our basic case is that there is violation of natural justice. So when we say that the order is vitiated because of the violation of natural justice and procedural lapses, Lordship, we are not differentiating the sections there. Although the learned trial court has also given opinions on the materials on record. To counter that, I have furnished all of the materials. We have to have proper argument on that, Lordship. Now, this point, I was never highlighted here. Now, because the other side has raised, that is why we have to clarify. That clarification opportunity was not given. Lordship has today given. I have closed my arguments on Friday. I said, I am stopping. I will not speak any word further. Thereafter, also, if Lordship has any query, or they have raised some pertinent points where there a clarification is required, that is what we have sought on 30th June 2021. So that opportunity is not there. Now, when we will be arguing before the learned trial judge, if Lordship remands, taking that Lordship is remanding the matter, we cannot differentiate between the IPC provisions and the UAPA provisions. We'll argue everything. My humble submission is that, as because if the records satisfy this Honorable Court, that we are not given proper opportunity. Lordship will not restrict us that we can only argue on the IPC sections only. We have to give in complete opportunity because all are interlinked, interconnected, all the provisions. Prima facie, Lordship, lot of materials are there, which can be clubbed for the purpose of having the ingredients of IPC as well as UAPA. Now, road blockade, disruption of the railway movement. Some of the accused persons standing and sitting on the railway track giving speeches there. One speech from the YouTube very clearly says, disrupt the economic blockade, shut down the state of Assam. What more is required? And his own person in one of the statement of the witnesses said, A1 is provoking the people who are gathered there to damage the properties. All statements are there, Lordship. I do not want to repeat the same thing again and again. So, regarding remand, Lordship, if Lordship is pleased to remand it, Lordship, then Lordship will give us full opportunity, not piecemeal opportunity, Lordship. That is my one submission. If it is violation of natural justice, it is for all the provisions. It is not that on 10th of June 2021, we have completed our submission regarding UAPA provisions. It was half done in respect of all the provisions. Violence is the product of the assembly. Who was organizing this? If suppose there are some other organizations involved, some persons lordship has all whether they were made accused or not. During the trial, there is a provision of section 319 of the CRPC. The court feels that there are sufficient materials to proceed against some other persons who were not named in the charge sheet. The Honorable Court can proceed. If I have to place lordship, CRPC section 319 is very clear on that. May I just place it? And our investigation was not complete till that moment because the very important technical evidence, the telephonic conversations, the data retrieved from the hard disk, as well as downloaded from the YouTube, those reports are yet to come. In our chart sheet, I have just indicated 319 CRPC. Power to proceed against other persons appearing to be guilty of offense, where in the course of any inquiry into or trial of an offense, if appears from the evidence that any person not being accused has committed any offense for which such persons could be tried together with the accused, the court may proceed against such persons for the offense which he appears to have committed. So very clear, Lordship. The law is very well taken care of all these things. And regarding not having section 320, our case is very clear. I have just said that it was on the basis of the activities of December and November of 2019, as well as the previous activities. So we do not think at that point of time that section 20 we have to, where it is said that punishment for being member of terrorist gang or organization, section 20. Our case was a clear-cut case of section 18. If that situation comes, Lordship, the Honorable Court has the power to add section 20 on our prayer or on its own.
So which are the sections where charge was charge sheet in the charge sheet?
Yes,
Which
charge
section?
sheet section 18
39.
and 39
UAP.
of the UAPA. And so far as IPC is concerned, 120B, 124A, 153A, 153B.
Yes.
124A,
153A, 153B. So conspiracy is in both. And when we read section 18 of the UAPA, it automatically links to section 15. Because 18 says terrorist act and terrorist act is given in section 15. What are terrorist act? Now, I may be wrong also, but the other side is said that there was no dynamite, bomb, and etc. But there also, Lordship will see section 15. See 15A.
yes.
This terrorist act, what are the terrorists already given on the first paragraph? A says, by using bomb, dynamite, and other explosive substances or inflammable substances. Now, inflammable substances is the tire burning, vehicle burning. Tire burning, there is a call that every home should have tire burn in front of their courtyard. There is a statement of one of the witness. Or firearms, or other lethal weapons, or poisonous or noxious gases, or other chemicals, or by any other substance that burning tire, whether biological, radioactive, nuclear, or otherwise of hazardous, or this is important, Lordship, last, or by any other means of whatever nature to cause or likely to cause, or by any other means that gives the handle to bring the offense under the provisions of terrorist act. By any means, sitting on the railway track will also come under there. Squatting on the railway track, squatting on the road. The person who was traveling through Khetri, he was directed, involved 500 persons to block the road at Khetri. There is a direction from A1 to one of the witness. We are harping on 15A, then Roman 2, A Roman 2. One also, because injury is there, that police officer. Cause death or injuries to any person or persons, injury is there. Actually, one is also there. 2, loss or damage or destruction of properties. I have given the full list with photographs where the gathering was organized by A1 and his comrades, lordship. Everywhere there is violence. And one of the witness very clearly says A1 through his speech was provoking the crowd to get violent. 3, disruption of any supply or services essential to the life of the community in India or in any foreign country. He was directing one of the witnesses that go and meet the station master. Cancel the train. He has also said that same person, the witness, that the witness said, I want to allow the train to move at 4 p.m. He said, don't allow that. So all these, lordship, the overwhelming materials are there. So this is regarding the violent protest as a byproduct. I am sure, lordship, it may be a byproduct, but who initiated? Who is the leader? Who requested the people to gather there and raise objection? In several telephonic conversations, he was saying that shut down Assam, shut down Dibrugarh, shut down Sibsagar, shut down Sabua. Go and create problem in Janta Bhavan, Dispur. That is the hub of the state. And lordship knows, I am not requesting this honorable to take judicial notice. No, it is a part of the record. How just in one of the conversation, he asked how many vehicles were burned in Dispur. 2 police vehicles and 1 small car. Those scenes are very much vibrant in our memory now, like a Hollywood movie. Those ghastly scenes of Dispur. We pass that road every day. And what was the plight? Japan Prime Minister was coming here, and overnight, whole area was vandalized. All the footpaths, dividers, banners, buildings, everything was destroyed. And who was the kingpin? Somebody is over phone directing his persons to do all these things. These are the telephonic technical findings. There is no reason to disbelieve the report of the Chandigarh.
What is the next point?
Next is many others had requested for gathering. Yes, many others, if they have requested, outcome we have seen. If the trial court finds somebody more are involved, there is no bar under the law. Section 319 is very clear on that. Then terrorist gang, etc. I have already said. Our case is that November, December plus 2004 onwards. Whether that 22/6/2009 notification has no relevance in our submission. That will satisfy the court if the opportunity is given to us. I think these are the grounds which I have given my written arguments, lordship.
Right.
So my humble submission is that if lordship is pleased to interfere with the impugned order, lordship would allow us to go there and argue the case into whole, not in piecemeal manner.
All right.
This is my humble submission.
Now,
Highly obliged, lordship.
just to give you a piece of what is going through the mind of the court, is that you see, obviously, this is one of those cases where there are complex and intricate issues involved, both of law as well as facts. And in these matters, the court is normally expected to or called upon to deal with these matters at different stages. Once maybe at the time of refusing or granting bail, the same materials come into play. Then this is a stage, framing of charge or discharge. Then there could be subsequent stages, and finally either conviction or acquittal. So in all these stages, these are the materials in different forms which will come into play if it goes to that extent. But the approach of the court has to be different on each occasion. Apart from the arguments on the grounds of violation of principle of natural justice, on merits, we cannot go very deep into this matter.
Yes.
We cannot go. We cannot give any observation, either convicting or acquitting anyone. Any observation which remotely has a bearing to that extent will be uncalled for.
It will prejudice one of the sides.
Yes,
later
it
on.
will prejudice one of the sides. So being circumscribed as much as possible, we will try to write out a judgment, giving our views on what we feel, after taking note of the submission of both the sides. That's what we'll do. The judgment may be small or big, but the preparation will take some time.
The
So as
difficult
you
part-
enjoy Bihu in peace, we will have to do the digging.
So that is a good, from our side, good material for Lordship to enjoy the Bihu vacation.
Oh, yes.
Number one.
Yes.
And writing précis is the hardest part, Lordship. To write the précis, we have to read the whole thing. Or the writing the synopsis of the case.
Correct.
My lord, Lordship will also take note of the fact that after discharge, I am at liberty. And if your Lordship decides to send him back for trial or, for framing a charge, then my lord, the consequences are there. I'm just indicating to your
Now, you
Lordship.
please address what is.
No, my lord, our concern is, well, prima facie, my lord, there is no case for framing. a
That's
charge.
on merits.
That is
your-
our argument.
that is
That
your-
is what we have done. And in the written argument, we have brought out everything, my lord, including what my learned friend has argued just now. Now, my lord, there are 2-3 possibilities. Your lordships could say, allow the appeal, whole of matter will go back.
Right.
In which case, my lord, I'll again have to, I'll be also sent to prison, my lord. That aspect, lordship will have to take care, number one. Number two, the other possibility is lordships might be inclined to take a view that since section 15(1)(a) materials are not there, therefore it's not a case for framing charge under UAPA. However, looking at the materials which are placed before this honorable court or court below, maybe lordship will take a view that there are materials for framing charge under other penal statutes. In which case, my lord, to which court the matter will go back.
So you are saying this court can send the matter directly to session judge?
No,
Then it has to go back
go
to
to
that
that same court. Even if for my lord, framing of charge under other penal statute,
court.
in which case, the court below can, my lord, say that since it doesn't fall under the jurisdiction of UAPA, therefore they will have. But there's no question of your lordship sending directly to the.
That's correct. Mr. Chaudhary, you see, we welcome all arguments. If there is anything you want to address, we welcome it. You see, these are very sensitive matters.
Yes.
And these criminal cases where there are bulk of materials, we have to be very careful
Of
in
course.
saying what we say. So therefore, hypothetically, we are trying to analyze if this is the outcome, then what could be the possible order? If that is the outcome, what could be the possible order? That is why these questions are made. Now, what is the point you are trying to make? Assuming that we set aside this order.
My lord, the point
No,
which
just 1 minute.
my lord, kindly give me-
Just a minute.
Yes.
I mean, it will help you.
Yes,
One thing you agree that the trial court, having observed that there are probably materials under IPC, could not have discharged. That you agree. So if that you agree, then this order in this present form cannot survive.
yes,
That much is for sure.
yes.
It will be interfered with. Now the question is,
What will
if-
be the extent of
what
interference?
will be the extent of interference? One,
There, my
as
lord,
he said,
if your
whole
lordship
of-
will kindly permit me, in the
Yes.
written submission, last page, para 11. Please have a look at that.
yes,
Written
submission
submission,
of
page
A1.
24, para 11.
A1.
A1,
all right.
para 11, last page. By A1.
No, how do we know which is whose?
So on behalf of respondent number 1, my lord.
Respond number 1 is
Yes.
yours. Okay, this is A1. All right.
Last page, my lord, para 11.
Yes.
That even at the cost of repetition, it is respectfully submitted that no case whatsoever has been made out by the NIA for framing charge against A1 under UAP Act. As the emphasis was on framing charge under UAP, AI comprehends that the aspect as to whether acts of omission and commission attributed to A1 constitutes other penal offense may not have been properly projected. Be that as it may, prima facie, there are no materials brought out in the charge event to frame charge under other penal statute. However, if specific materials having direct bearing on framing charge under other penal statutes can be highlighted against A1, it would be within the judicial discretion of this honorable court to take an appropriate view in the matter.
So what is that appropriate view? according to
Appropriate view could be, my lord, remand the matter to find out whether these are there, or lordship may find, having gone through the evidence, lordship may have a feeling or may form the view that maybe these are materials good enough for framing of charge under other penal statute.
No, so therefore there are two aspects here.
Yes.
First of all, the learned special judge,
No, no, their learned single judge has dealt with in respect of all the offences dealt with.
so that's correct.
There, my lord,
Hmm.
in respect of IPC offences, it is very difficult to, my lord, at this stage of charge, framing of charge, that whether this would be sufficient or not. But my lord, in case of 15(1)(a), there is a specific requirement. It's not very difficult to decipher that.
No,
That is the reason I am saying, now, my lord, for example, my lord, in my written argument, I have indicated, my lord, in which paragraph the trial judge has dealt with which aspect. For example, I'll just give an example, my lord.
Mhm.
If your lordship would kindly come to page 16. Oh, not 16, my lord, I'm sorry. I'm sorry. Yes, my lord will kindly come to page 14.
Yes.
One second. 14, 15, and 16, my lord, I have indicated the learned trial court has dealt with what aspect. So going by this, lordships will find, even in case of IPC offences, the trial judge has dealt with everything. So if on reappreciation or going through lordship forms an opinion,
Mhm.
as I've already submitted, my lord, when it comes to material constituting an offence under IPC,
Hmm.
there are scope of argument on both sides, my lord. But in case of 15(1)(a), it is not possible. The means adopted must be XYZ, and any other means, my lord.
No, that's correct, Mr.
Yes.
Chaudhary. What the question that is being posed is slightly on a
Yes.
different line.
No, no, I have followed. What your lordship wants to.
Let me put it. The question is what he's submitting, and we are looking for an answer for that. He's submitting that
If
the
you remand,
learned special judge himself has observed that there could be materials to frame charges under the IPC offences. So it is therefore not a per se discharge under the IPC offences. But he has not referred the matter to the sessions judge. Now, what he is arguing is that if the court is convinced that this is a case where there has been violation of principles of natural justice, or for any other reason, the court finds that the order is perverse, then whether or not there are ingredients under UAPA Act and no ingredients under UAPA Act and ingredients under IPC, this is a composite exercise. This exercise, this court cannot do. The court has to only see whether the order is vitiated. If so, the entire exercise has to be redone.
my lord,
What do you
this-
have to say on that?
Yes.
Is that
This-
your argument?
This submission is fallacious because, my lord, appellate court's power is always coextensive with that of the trial court. If trial court could have framed charge under IPC offence and discharge under UPA offence, your lordships can also do. Where is this big law point involved, my lord? The argument is fallacious, which is that law which says that if your lordship finds that there are materials for framing charge under IPC offence, but not under UAPA, your lordship is obliged to set aside the whole order and remand the matter to the authority for decision afresh. There's nothing like it, my lord. But in fact, it doesn't stand to any logic. It does not make any sense. Appellate power, my lord, it is coextensive. That's why I'm saying, my lord, as has been observed by the learned trial court also, and also having regard to the fact that when, my lord, a special statute is, made, my lord, that too when it is a special panel statute, then, my lord, the court has to take care because the consequences following from a special statute is something very grave. Therefore, court has to be on the guard, because unnecessarily court will not permit, curtailment of liberty of a citizen or a person, my lord. That is the reason why extra care is required to be taken. Well, we all know, my lord, at this stage of framing charge, it's a very difficult exercise. Whether to refuse or even to decide on the appellate side also, my lord, this is a very tricky issue. Because, my lord, if a lordship makes an observation, it may have a bearing on the trial. So many aspects. One has to take a very
And if
balanced
you don't
approach.
make an observation, how does one know on
No,
what
no,
consideration?
what
it
I'm
has
saying
been
is, my lord, at least here is a case with my little experience in the profession, my lord. Since 15(1)(a) is not fulfilled, therefore, UAPA is out of question. From whatever angle we test it, my lord. That I have already made my argument. But on the other aspect, my lord, as a appellate court exercising coextensive jurisdiction, if a lordship can always remand the matter to the session judge for finding out whether charges could be framed under other penal statute.
Yeah.
After, of course, your lordship will have to be satisfied that the materials on record, there are possibility that it could be said that the charges could be framed under other penal offense. That's my humble submission.
I just want to
Oh,
just
happy.
add what my learned friend has said. So my learned senior friend is saying that lordship may indicate that charge or lordship may frame charge under IPC and remand it back.
No, he's not saying that.
Indicating, this is what he said.
He's saying that even if the matter is remanded, it should go with a rider that the court should only examine whether the materials
Yes.
are
Now,
sufficient to frame charge
What
under IPC.
I have come before this honorable court. What is my prayer at page 38? My prayer is that to admit this petition, call for the issue notice so and so as to why the final order impugned order dated 1/7/2017 passed in so and so should not be set aside. Subsequently, the same prayer and remand the matter back for framing of charging as respondent so and so. We have not prayed. Prayer B, lordship will kindly have a look.
Mhm.
To set aside at the impugned order 1/7/2021 passed by the special judge NIA in special case number so and so and remand back the matter for framing of charge against respondent accused so and so. Page 38 of the memo of appeals. We are not saying that lordship may be pleased to remand the matter for framing of the charge under a particular section, under a particular act. That decision will have to be taken by that court, whether it is IPC or UAPA. We do not want to lose one forum. And this is not a writ proceedings. There is a special procedural law, CRPC. That procedural law have to be abided by in stricto sensu.
All right, so we close the matter
Highly obliged, Lord.
unless you have anything to add.
No.
No, but
Or else, my lord, it will be too meme. It will go on.
No, it is not
No, it's not.
It is a learning process. This case.
it has been very erudite submissions from both sides, making our job very difficult.
My lord, I have tried to put in some substance in the written argument also, from the legalistic point of view.
Take down heart, Mr. D. Sekal and senior counsel.
In fact, this is a subject over which, my lord, we don't have much of
No,
mastery, my lord. So we have tried to assist your lordship.
they're all evolving.
Yes.
Mr. L. Satyanarayana, counsel for the appellant. We have also heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R. Sensway, appearing for the appellant in
A1, R1.
Appellant in R1 in
R1
Is the
and
accused
Mr.
number-
S. Bhattaku, learned counsel representing
and my learned friend for
phone
2, 3 and
numbers
4.
2, 3 and 4. Arguments concluded, judgment reserved.
Highly obliged.
One aspect,
Deep
Your Lordship, I want to point out, Your Lordship, that Sabua case, Your Lordship, criminal appeal number 122, Your Lordship. This is tagged with this 121, Your Lordship, but that has not been heard.
That may be segregated. That
That
is a
may be
different case.
Acha, that is criminal appeal 121, 122.
122.
Acha,
We'll
these-
argue differently, Lordship.
This order is in criminal appeal 121. Huh? And the other matter you write, so and so for so and so, so and so for so and so. Let this matter be segregated from appeal 121 and listed separately for hearing
Lord,
after 3 weeks.
Lots, highly obliged.
obliged.
Yes.
Daily list for admission, item 2.
Yes.
Here this appeal is filed against judgment and order dated 3/3/2021 by this passed by the learned special judge Bonaigaon. And here the appellant is sentenced to
Appeal against conviction.
conviction law.
6 and 8 of POXO Act.
The
We'll
POXO
admit
is
it that heard Ms. L. Devi, learned counsel for the appellant. This appeal is presented against the judgment dated 3/3/2021 passed by the special judge, Bonaigaon in connection with special bracket P bracket close case number 13/BGN bracket close. BGN in bracket close, /2019, convicting the appellant under section 6 read with section 4 of the POXO Act.
8. No, Lordship, POXO was not established here. It's under 376, Lordship, 376, one of IPC. Because POXO was not proved.
Why are you saying POXO there?
But in the
Yeah,
cost
but
title
it
also.
was not, it was not.
Under section 376 bracket 1 of the IPC. And sentenced to
Rigorous
to
imprisonment.
undergo rigorous imprisonment for 12 years and also to pay fine of rupees 2,000 with default stipulation. First of
Oh,
We
this
have
is a
paid
wrong
the
file I'm getting.
impugned judgment. Stop. Also had submissions made by learned counsel for both the same. Report room is as Jahan for learned APP for state. First of admit the appeal, call for the LCR. Issue notice returnable in 6 weeks. Since Ms. Jahan has accepted notice on behalf of the state, respond number 1, no formal notice is required to be sent to the state. Steps by registered post with AD for service of notice upon the victim informant. Yes.
Actually, I made a prayer for the interim, but I have not filed it. I have made it on the prayer.
Acha, you have to file because they are entitled to
Yes,
make
Lord,
a.
I'll file this. He obliges me.
Item 3.
May I please your lordship. This appeal has been preferred against the order of rejecting bail fare of the accused petitioner lordship. Accused appellant. By the special judge NIA. Is 21 annexed to your lordship will find that.
Okay, we'll admit it and post it for hearing that.
Lordship, in the meantime, I will file my objections, Lordship.
File objection,
In
produce
the
the case.
meantime, lordship may call for the scanned copy of the case record.
That,
They will produce the case.
that will be there, Lordship.
Heard Mr. P. Chaudhary, learned counsel appearing for the appellant. Also heard Mr. R.K. D. Chaudhary, learned DSGI appearing for the respondent. This appeal is directed against the order judgment and order dated 16/9/2022 passed by the learned special judge, NIA in NIA, Assam, Guwahati in connection with Miss. Case bracket NIA bracket close number 08/2022 arising out of RC 05/2021/NIA dash GUW, capital GUW, capital NIA, capital GUW. Whereby the bail prayer of the appellant was rejected. Full stop. Admit the appeal. Issue notice returnable on. When do you want it?
Lordship, can it be in the second week of February, Lordship?
Can it be in last part of January, lordship?
No. 6th of February, let's have it. 6th,
Lush.
2022.
Lordship.
Since the respondent is already represented, no formal notice is required to be sent in this case. The appeal will be taken up for final hearing on the next date. Let it make it 7th of February.
Lordship.
On the next date fixed. In the meantime, the respondent may file objection, if any, by serving advance copy upon the appellant's counsel.
Lordship.
We learned DSGI to also produce the case diary on the next day.
Obliged, Lordship.
Item 4.
This case is under 6 and 8. I was holding a wrong file then.
May I please your Lordship? It will be appeal against conviction,
We'll
Lordship.
admit it.
Lordship.
Heard Mr. V.H. Chaudhary, learned counsel for the appellant. Is also heard Ms. S. Jahan, learned deputy Assam appearing for the state. His appeal is presented against the judgment dated 29/11/2022, passed by the learned
Additional
special judge,
special
comma,
judge.
Poxo, comma, Kamrup, bracket M, bracket close at Guwahati, in connection with this is additional session, additional session judge come special judge Poxo. Kamrup M at Guwahati, in connection with sessions case number 415/2018, whereby the appellant was convicted under section 6, read with section 8 of the POXO Act, and sentenced to indirect
Reversing to
I read for
25 years.
25 years.
25 years under
sentence to-
section 6.
undergo RI for 25 years and also to pay fine of rupees 50,000.
20,000.
No, what is it?
20,000.
Page number 52.
25 years and pay fine of rupees 20,000 with default stipulation for committing the offense of section 6 or committing the offense under section 6 of the POXO Act. First of the appellant was also sentenced to RI for 5 years and to pay fine of rupees 5,000 for the offense committed under section 8 of the POXO Act. First up, we have perused, both the sentences are to run concurrently. First up, we have gone through the impugned judgment, also considered submissions made by learned counsel for both the sides. Admit the appeal, call for the LCR, issue notice returnable in 6 weeks. Since Ms. S. Jahan has appeared in accepted notice for respondent number 1, no formal notice is required to be sent to the said respondent. And this petition appellant to however take steps for service of notice upon respondent number 2 stroke informant by registered post with AD.
Actually, I have also filed an I Lordship. For
I'll file
suspension
my
of
objection.
sentence.
2 weeks.
All right, IA invite so and so for the applicant. This IA has been filed under section 389 bracket 1 of the CRPC. With a prayer for suspension of sentence and also for releasing the applicant on bail. Ms. S. Jahan, learned APP Assam, prays for 2 weeks time to file objection. Prayer. Let this matter be listed again after 3 weeks or immediately after the objection is brought on record, whichever is earlier.
Highly obliged, Lordship. Highly obliged.
Item 5.
My Lordship, there is a delay of 105 days in filing this appeal, whereas the accuser is convicted and undergo convicted and sentenced to
Will you
undergo
confirm the
14
delay?
years of.
105 NDPS case and we are the, I think, the informant here, the police personnel.
Yeah.
Let it be heard.
Not Ms. J. Ms. J. Paul, learned counsel for the applicant, also heard Ms. S. Jahan, learned APP Assam appearing for the state. His application has been filed under section 5 of the Limitations Act, 1963, with a prayer for condoning the delay of 105 days in filing the connected appeal against the judgment and order of conviction dated 30/5/2022, passed by the learned sessions judge, learned special judge, Morigaon, in NDPS case number 03/2022, convicting the appellant under section, convicting the applicant under section 22, bracket capital C, bracket close, read with section 29 of the NDPS Act. Full stop. We have gone through the explanation furnished in the application explaining the delay. Full stop. Ms. Jahan submits that she has no instruction for filing any objection opposing the prayer made in the IA. Full stop. Taking note of the explanation furnished by the applicant, And having regard to the fact that the connected appeal is against a judgment and order of conviction, whereby the applicant has been sentenced to RI for 14 years and also to pay fine of rupees 1 lakh. We are of the considered opinion that this is a fit case where the delay of 105 days deserves to be condoned and the appeal be heard on merit, full stop. We accordingly condone the delay of 105 days in filing the appeal, full stop. Registry to, on office to number the appeal and list the same for admission. IA stands disproved.
Appellate roll.
Supplementary list, item 6.
Interim bail is okay, huh?
Now he can jail again.
Fine there.
So now sick bail. Maybe lordship. My lord, as per your lordship's earlier order, your lordship granted 3 weeks time, allowing me to join in my wife's delivery matter. And now my wife has delivered a child and the child is nearly 4 weeks now. At my house, my lord, there is nobody at all. Only I, myself and my wife, only some neighbors are looking, but they cannot look every time. And so far merit of the case is concerned, I have already surrendered as per your lordship's direction. And I have filed an IA also, annexing the Okalatnama of the district jail. That is IA number 9, 2003, madam. Kindly see. And all the medical papers. First, kindly see page 16, the medical papers, etc. 16 onwards. Savitri Healthcare, a birth certificate, Mithu Rai Chaudhary, my wife, baby of Ontu De.
Conviction is under 302.
No, 376. madam.
376.
But 10 years, my lord. Now, lordship, I will satisfy your lordship, my lord. There is no case at all.
No, that earlier bail application was disposed of.
No. Earlier was pending. Only
Achha.
3 weeks time was granted for attendance of my wife's, that's in the critical condition. So for merit of the case, my lord, kindly allow me to say something. That's what type of case is this, my lord? My lord, I invite your lordship, kindly see page 33, my lord. Page 33 of the paper book.
No objection.
You are arguing the appeal on merit today.
No, only for bail, my lord. For bail, my lord, there is something, my lord. I will say first thing. Voluntarily
That's all
after-
right. That's not a favor done. If you did not comply, we would have hounded you down and taken you back to the. That's not an option. Since the paper book is ready,
Paper
Can this
ready,
appeal
but
be
for
finally
hearing the
heard?
appeal, my lord, we have to prepare something in a very better manner, my lord, because for
what do you
the
have to
bail,
say on the bail?
prima facie lordship will be satisfied. Kindly allow me for time table. Your lordship will be fully satisfied. First thing, my lord, there is delay of 2 days in closing FIR and at police station only 10 minutes away. It is on.
IA number 9
Oh.
of 2023. Have you got the copy?
No, Lordship, in fact,
Then
there is.
please, why don't
Ha,
you
ha.
please listen to what we are
Yes,
saying
yes, yes.
first? You have not received a copy of IA number 9 of 2013.
No, I number 9, I don't have it today.
That is the problem. He wants an order in IA number 9.
9,
You
I
don't have the copy, you have not filed objection.
9, I
Here-
have not filed. Earlier one, that is 176 or 423 I filed. 423 is also there today on record.
In IA, my lord, objection may not be necessary. It is only information, my lord.
Heard Mr. M. Mohammed Leonard, counsel for the applicant, also heard Ms. S. Jahan, Leonard APP Assam appearing for the state, who submits that she has not yet been served with a copy of the application filed in IA criminal number 9 of 2023.
More, we have to 9 idea.
It is served without submitting, we cannot file anything, but she may not have. But
I
that is,
have
my
the
lord,
paper book.
that is not nothing to be objected. That's only information that I have carried out order of the court. My bail matter is, that is, my lord, 423. In that case,
423.
she has filed objection.
Objection of copy to
अपने इंजीनियर ने वोट दिया नहीं।
You have made a prayer to allow him to go on bail. during the
In
period.
433, my lord.
No, in
423.
in IA number
No,
9.
in IA, I have said that now the main case, IA number,
Oh,
IS.
Mr. Mahmood, it's getting very difficult.
Yes.
You see, when you appear in the cases,
No,
you are always twisting things. Just now you said this IA is not about bail. Then we find in the prayer that you have asked for allowing your client to go on bail.
no, my prayer may be seen by page 5 bottom, can you see? Page 5 bottom. To allow
On the request of
423.
Ms. Jahan, we direct the register to list this matter again on 18/1, no, yes, 18/1/2023. It was to enable her to file objection, if any, in the matter, full stop. If you want to file objection, you file, otherwise we'll take it up on merit. What he's submitting is incorrect. He said this is not an application seeking bail, but there is a prayer seeking bail.
So I'll file my
We'll see.
objection.
And he's saying there is no one in his family to take care of his wife and child. So you have to specifically respond to that. What is your stand in the matter?
That cannot be a ground under 389 because nobody to look after. Won't be.
Then you put
I'll have to.
put your stand.
Yes.
You have to put your stand. Earlier application was some other ground, you filed your objection. How can you use that in this application? So it is completely, doesn't make any sense what he is arguing and then your response. If you filed an IA, she has to be given time to file
No,
objection.
copy is given, served in office, my lord. No, no, my life.
I'll take a copy.
I'll serve a copy,
I'll
no
take a
problem.
copy.
That is no problem.
Mistaken on 19/1. 19/1/2023.
Almost.
Did you know, copy?
Part two matters,
Yes.
item
Yes.
1, 3, 4, 5, 6, 8.
Part two, any small matter we can do because this bench will not be available for God knows how many weeks. So we can hear, but the matter will get stuck up if it is a bulky matter. Anybody who wants to do that, we have just received the roster. This bench is not going to be available after tomorrow. For how long, we don't know. So any matter where judgment cannot be dictated in the court, if you start the hearing, you will have to wait till the bench is again available. That is the position.
After
Who wants to do a hearing, we welcome you. But you must know this. My brother is going in outlying bench. If there is a short matter, we can,
69 is not short matter, my lord. It will take time.
and it will take time. You want to do it, you do it. But if we start it, we will proceed with the matter again when this bench is available. These are some practical difficulties. What you want to do? If there is a short case where it can be heard and judgment dictated in the court. How many witnesses in your
6
matter?
witnesses.
Why did you go away? We are looking for you the other
No,
day.
on last occasion, I was in another court, lordship, that is, I'm sorry, lordship.
You upgraded the matter, then we
I thought
reserve
that
the
lordship,
judgment.
that matter will take time. That is why I was other court, when
If
I
you
come.
think, then it is at your own peril. We can't help it. You express urgency, then when we
Yeah, it's a urgent
when
matter.
we concluded other matter, when we are calling your case, you are not there.
I'm sorry, lordship, I'm sorry.
So what do you want to do? If you want to start argument, you can start. But if it is not concluded,
Other side also, is there, the AC is not, for NCB.
who's the other side?
NCB, lordship.
LCB.
NCB, SC Cal, Narcotic
Oh.
Control Bureau. I can.
Then if the other side is not there,
And
tomorrow practically the court functioning will be very, very restricted.
Yes, lordship.
And then the bench compositions will change from 17th onwards. If you want to start, what happens is the matters where acquittal is to be granted, then it gets stuck up. If the honorable judge, who is the partner in this bench, is sent to outlying benches, then it is delayed because the records will have to be circulated, judgment has to be settled. So.
In this case
What do you want to
only-
do? You tell us. We
Yes,
have no
we can
difficulty.
do lordship.
Yes, you can do,
Yes.
but we'll
My
make
part-
it parted and the judgment may come in March.
Lordship.
We don't know.
It's leave up to your lordship.
No, it is not a question of up to. We will hear today, if it is not concluded, the next, the matter will be listed again when the bench is available.
I
And
understand.
judgment, will obviously, we have heard some matters, so those cases will deliver judgments first.
Then after.
Do you want to do it now or you want to do it on 17th? That is your option.
17
You take
lordship.
the option. We can't help it. It is not possible to deliver all the judgments in one day.
Lordship, lordship. It's a big matter, lordship, because some involvement there, 4 persons are there. They will also argue on this point, lordship.
The other side is
Other
not-
side, as CKL is representing, I think, lordship, SG will be here, lordship, for their department. And
Then you
is-
do it on 17th.
lordship, lordship,
Make a synopsis.
I have prepared and
17th, 18th, we can continue on day-to-day
lordship,
basis
lordship,
and conclude and immediately prepare the judgment. There's no point hearing a matter and then not being able to give a
Lordship.
judgment.
I'll inform the other side also.
So any other matter which is short and can be decided without reserving the judgment or without rolling it over. All right, then we'll rise. Yes. Then we'll work on the judgments in the matter.